Anti-war activist Jim Dowling appeared in a Brisbane court today, charged under Queensland's new hate speech law after displaying a sign at a march protest outside Boeing's Brisbane headquarters that read, quote, "From the river to the sea, Brisbane will be free of Boeing." According to the ABC, Dowling told the court he wanted to, quote, "plead insanity because he believed the law itself was insane." For context, Queensland's new law came into force on the 11th of March 2026 after last-minute amendments that explicitly banned certain protest phrases. Critics say Parliament rushed it through and brushed aside serious free speech concerns, but the government argues the changes were needed to confront rising antisemitism and to protect people trying to live, worship and gather safely. Many in the Jewish community say that a recent uptick in hostility has become impossible to ignore, but whether that justifies these new laws is a topic that's extremely contentious, with critics often arguing that it's not public safety, but rather the Israel lobby that won a victory as a result of these new laws. But whether that's true or not, the bigger issue here goes far beyond Israel and Palestine. Writers from Orwell onward have warned us about quote-unquote thought crime, yet Australian law has long concerned itself, rightly or wrongly, with states of mind and people's intentions. What is changing is not that the law now suddenly cares about thoughts or feelings, it is whose thoughts and whose feelings we're now focusing on. Over the past 30 years, legal reform has steadily shifted attention away from what a speaker meant and toward what an ordinary listener might think or feel. At the same time, juries have been given less room to apply common sense in order to reach their own conclusions. So while Queensland law still allows a reasonable excuse for genuine political or public interest expression, in practice that protection can be hard to use. The burden falls heavily on the accused, and their ability to explain themselves is often tightly constrained by judicial rules that are arguably designed to prevent them exercising any meaningful narrative agency over the matter brought against them. That is obviously a dynamic the public would want to debate, yet so far there really has not been one, and I think most people do not even know that this is happening. And that, I think, is the real story here. Regardless of what one person or another might think about Israel-Palestine or the new hate speech laws, there's actually more at stake than freedom of speech and emotional safety issues. There's also the fact that ordinary Australians have never really been told what's really going on in our courts. Most of us have never been told about the normalcy of hypothesizing about brain states in legal decision-making, the shift away from intentionality, or the silencing that is nowadays a mainstay of the criminal justice process. And without that discussion, the overall democraticness of any of this is hard to vouch for. This has been Hero to Zero News. Subscribe to stay up to date with privacy, accountability, and citizen rights stories as they unfold.